Welcome to The Explainer. So, today we're going to dismantle a deeply ingrained, kind of romanticized story that we've all been telling ourselves for centuries, really. It's the myth of the lone genius inventor. You know the one, right? We've all been taught to picture this isolated visionary just toiling away in a dark garage, pulling entirely new, world-changing ideas out of absolutely nowhere, out of an absolute vacuum. But as we're going to see today, the actual mechanics of human innovation, and honestly how our legal systems struggle to govern it, tell a completely different, and frankly, a much more complicated story. I want to start things off by asking you a question that really challenges the core assumptions we hold about creativity. Think about it. When two different people, or maybe two competing companies, come up with the exact same brilliant idea at the exact same time, did one of them steal it? I mean, our immediate instinct is usually to look for the copier, right? We just assume that overlapping inventions are always the result of theft. Like if someone else has the exact same product, they must have peeked over the fence. Well, not necessarily. But to really understand why we jump to that conclusion so fast, we kind of have to look back at how we historically valued human effort. Okay, let's dive into this. For decades, there was this really prominent old legal idea known as the sweat of the brow doctrine. Sometimes you'll hear it called the industrious collection theory, and the thinking here was actually pretty straightforward. Society basically believed that if you just worked incredibly hard, if you really sweated over a project, like, say, spending years manually gathering and verifying public facts just to put together a massive directory, well, the law should reward you for that effort. The whole point was to stop lazy competitors from just free riding on all your sheer time and labor. And, it sounds perfectly fair on paper, doesn't it? It basically values the physical and mental effort itself as the true source of originality. But there was a massive, glaring flaw in that logic. When you look at the U.S. Constitution, specifically Article 1, Section 8, the core requirement for copyright is original works of authorship. Notice it doesn't say a single thing about mere perspiration. If we just rewarded pure effort alone, companies could literally monopolize basic public domain facts just because they worked really hard to gather them together. And this entire sweat of the brow illusion, it met its spectacular end in a landmark 1991 Supreme Court decision. It was called Feist Publications versus Rural Telephone Service Co. Basically, a telephone company tried to claim copyright over a basic alphabetical white pages directory just because it took a ton of work to compile. No way, said the Supreme Court. They unanimously tossed the industrious collection theory right out the window. They ruled that intellectual property requires a spark of true originality, an undeniable creative choice, and not just, hard work. So that brings us to part one, the twist. Let's take a look at the combinatorial kaleidoscope. So, if it's not just hard work, where does that creative spark actually come from? Well, sociologists point to something called combinatorial creativity. Now, creativity isn't about creating something out of absolutely nothing. You aren't just pulling ideas out of thin air. Instead, it's almost entirely about rearranging what is already there. It's taking items from a vast, shared database of human knowledge and ordering them in a way that makes them strange, making these novel and totally unexpected combinations. Even the greatest inventors in history, they were mostly just reordering existing concepts. And this brilliantly illustrates a point made by Mark Twain. He had this absolutely gorgeous poetic metaphor to explain how this all works. He called the human mind a mental kaleidoscope. Just think about how a regular kaleidoscope functions. Every single time you twist it, the exact same colored glass pieces tumble and fall, and they form an entirely new, beautiful pattern. The pieces themselves aren't new, right? The glass is the exact same glass that was there a second ago, but the specific arrangement, the pattern, is totally unique. And that is exactly how human invention functions. We're all just twisting the same shared kaleidoscope of scientific and cultural knowledge. And because we are all looking at those exact same colored glass pieces, it turns out that the old saying is absolutely true. Necessity really is the mother of invention. Current market conditions and technology constraints consistently force multiple parties to work independently on the exact same problem at the exact same time. It's not some crazy coincidence, it's a structural inevitability. Because of those shared constraints, our history is absolutely littered with simultaneous inventions. We're talking about massive, world-changing breakthroughs here. The steamboat, the cotton gin, the telegraph, the telephone, the airplane, the laser. These weren't just isolated moments of lone genius. In almost every single case, multiple people, completely unaware of each other, were racing towards the exact same finish line. The sociologist Donald Campbell actually compared this to rats in a maze, though, hopefully slightly better dressed. When multiple inventors are independently discovering the exact same path, it's simply because that is the path that's there to be discovered, based on the current limits of physics and engineering. So yeah, it pretty much completely destroys the myth of the sole inventor. Which brings us to part 2, the collision, copyright versus patents. So what happens when this reality of simultaneous invention just smashes headfirst into our legal system? To understand this, we've got to look at a really fascinating philosophical thought experiment, one that perfectly divides copyright from patent law. On one side, we have artistic expression, which is what we call author individuated. If William Shakespeare had died as a child, society would never ever have gotten Hamlet. That specific sequence of words is entirely unique to his personal creative choices. But on the other side, we have functional invention, which is structure individuated. If Isaac Newton had died as a child, society still would have discovered calculus. In fact, Gottfried Wilhelm Leibniz discovered it completely independently around the exact same time. Inventions are essentially pre-existing structures of the natural world, just waiting to be uncovered by whoever twists that kaleidoscope the right way first. So the crucial point is, here is where the legal hammer really drops. In copyright law, if you independently write a song that sounds exactly like mine, but you can prove you never actually heard my song, you're safe. That's called an independent creation defense. But patent infringement, that is a strict liability offense. Because the law views inventions as single discoverable structures, patent law completely refuses to recognize an independent creation defense. It literally does not matter if you spent millions of dollars in R&D and never once looked at a competitor's notes. Under the law, innocent, simultaneous inventors are treated exactly like malicious copiers. The first person to sprint to the patent office gets a total monopoly, and the second person, well, they get sued. And that leads us to part 3, the consequence, navigating the thicket. When you apply a 19th century legal framework, a framework that was really designed for simple, standalone physical inventions, to our deeply cumulative, highly interconnected modern technological landscape, things get messy fast. Just let this number sink in for a second. 250,000. That staggering, honestly shocking figure actually represents the estimated number of active, overlapping patents covering just a single modern smartphone. 250,000 individual legal protections touching literally everything from the antenna all the way down to the pixels on the screen. It perfectly illustrates just how hostile the modern technology landscape has become for anyone trying to build something genuinely new. Economists actually have a specific name for this corporate capture crisis. Back in 2001, UC Berkeley economist Carl Shapiro defined what we now call a patent thicket. And it is exactly what it sounds like, a dense, suffocating web of overlapping intellectual property rights that a company literally must hack its way through just to commercialize a new technology. Picture this. You've got a viable, incredible invention. You independently developed it, you have the funding, you even have a market ready for it. But standing right between you and the consumer is an absolutely impenetrable tangle of legal rights. It's no longer a competitive market at that point, it's just a legal minefield. And the real-world consequences of treating independent inventors exactly like copiers, they're devastating. This kind of corporate hoarding completely stalls human progress. Instead of actually encouraging product development, massive companies use these thickets as defensive shields to protect their turf. Or, even worse, they weaponize them as offensive tools to absolutely crush smaller competitors. They drain massive resources in court, and most importantly, they block subsequent vital improvements to existing technology. Viable, independently created inventions are prevented from ever reaching you, the consumer, simply because someone else twisted the kaleidoscope a fraction of a second earlier and locked up the patent. Which leaves me with the final, kind of provocative thought for you to chew on today. If we know that human innovation is fundamentally combinatorial, if invention is really just twisting a shared cultural and scientific kaleidoscope, shouldn't our laws protect the unique pattern you created rather than letting corporate giants monopolize the actual pieces of glass themselves? Definitely something to think about the next time you hear about a massive patent lawsuit. Thank you so much for joining me on this explainer. Keep wondering, and I'll see you on the next one.